First matter is Stonehouse Apartments versus Erica Eby. File number is 251976LT. Mr. John Bradshaw is here on behalf of the plaintiff. Ms. Collins, is this your complex or are you Vista Meadows?
No, she's on the next one.
All right. We were here on November 7th, which was a week ago. We determined that rent was $1,702, $198 in costs, for a total of $1,900.40.
If I might, Your Honor,
yes.
just to clarify, after I left you, there was, I noticed again, a late fee that I had to reduce. So I'm showing rent at that time was $1,672 plus the $198.40 in cost for a total of $1,870. Since then, the defendant has paid $1,015.
Can I say something?
Just a minute.
Okay.
Sure, you will, but 1,015. So what's the current total?
The total current owed is $855.40, and I'm breaking that down for the $657 in rent, and then of course the $198.40.
What's the total?
What was $855.40.
All right, Miss Eby, you apparently made a big dent on this. Do you think those numbers are accurate?
No, because I have paid my rent every month. I have a dog, and my dog is ESA certified, and she's charging me for that.
I think they're allowed to.
I am charging her $2 a month for a pet.
Yeah, but I have proof that her and I talked before I even signed a lease, and she said that as long as I have paperwork saying they're certified, that I don't have a charge.
Well, what controls is what's in the lease, not
Right.
what somebody told you. So let's take a look. I don't think there's an exception for ESA certified. A pet is still there. The pet is in the building. People have allergies. The pets are using the grounds. You have to pick up after them. So certified or not, there's a ramification to the complex. I don't think there's an exception. People want to have a horse, a mini horse or something as a certified animal, or a potbelly pig. The lease says, let's see if we can find the pet clause. Yeah, it lists your pet, the brown mix, 63 pounds.
The pet fee.
Pet policies. I'm sure the fee is.
I'm showing, Your Honor, under third page at the bottom, tenants shall pay
There it is, $30.
$30.
Yeah, it's in there. It's in the lease, and the lease controls as opposed to what someone told you. So you did a good job of getting caught up. You're really not very far behind now. Do you think you'll be able to pay this within 10 days?
No, because my rent is $1,000 a month, and I paid all of that every month. I'm the only one that lives there, and I'm the only one that pays all the bills. And I barely make it.
I would offer, Your Honor, that I could do a conditional dismissal.
Are you gonna have to speak up? I'm
Sorry,
not sure
yes.
she
I
heard.
could do a conditional dismissal, ma'am, which would allow you to pay this without a judgment, and I could put this out to the end of the month, which is, let's call it the 1st, because the 30th is a Sunday, so that gives you a little bit extra time.
Can't we push it out to where I get my taxes, then I can pay it off? Because
Well, they can agree to do that. They can give up to 56 days from today to
But I don't have that authority to.
ask for the writ and then 56 days to serve it. But he can go till, of course, on December 1st, another month's rent is going to be due.
But it wouldn't be part of this case.
Yes. I'm just gonna do a traditional judgment.
Okay.
It's really not that bad. Now, they can agree to work with you to get caught up on this. The rent, I wish I had a judgment. Did you bring one?
I do.
That's
Yeah,
okay.
'cause
Yes, please. Sorry, go ahead.
Because the late fee is outrageous, too. $65 a late fee.
He reduced
I
it.
reduced it.
By $100 and some dollars. I allow $40 a month, so the late fees were reduced.
Okay.
Good morning. And so that brought it down by $100 and some dollars. So through November, rent is $657. That's not that bad. Court costs are $198.
Wait, what'd you say rent was?
$657 through November.
No, my rent is 900 and,
No, the amount that's due,
oh,
not
okay.
that, not a month's rent, that you, it's just a part of the month.
Okay.
$198. So you made a big payment, and that's very helpful.
Yeah.
So 657 plus 198.40 is 8. I'll add it myself. I can't read my own writing. 657 plus 198.40 is 855.40. Now, that's due theoretically within 10 days. 10 days from today is November 24th. Now, November 24th is the Monday before Thanksgiving. Probably nothing much is going to happen. But at some point, December is going to come and there'll be another month's rent due. Let me repeat this. They can agree to work with you to get caught up on the rent, but a partial payment will not prevent the writ of eviction. You have to pay the whole thing. And I'm not entering any money judgment. You also have 10 days to appeal this. My suggestion is you go in and talk to your manager about getting caught up on this. The pet fee in the lease controls what somebody might have told you verbally.
Yeah, like I want to dispute that because I've got messages and emails from her reassuring me that as long as it's ESA certified, that I won't be charged a security deposit and I won't be charged rent every month because that's why I moved there.
Well, what's in the, you can take it up with the management, but what's in the lease is what controls here. And it shows they list your pet, a 63-pound mixed brown dog, and it says clearly at $30 a month. All right, so Miss Eby, I suggest you go talk to the management about some plan to get caught up on this and ask about the issue with the dog. If you got something that you haven't presented here, maybe this could be altered. But right now, your rent is less than a month, $657. So it's partial rent for November plus the court costs. Hopefully you can get caught up and stay in your placement. All right, ma'am, you're good to go. All right, we got iPhone here. What's your name, ma'am?
Oh, Christina Nichols.
Ms. Nichols, we were trying to get a hold of you.
I'm sorry. I don't know why I didn't get nothing from anybody. I mean, you might have called, but my phone is the settings are set on if I don't know the number, it doesn't even ring. I just got all these because I have so many scam calls. So I just got all these missed calls all the time, and I'm sorry. It's my fault. My
All right,
bad.
well, let's talk about your case. This is Vista Point versus Nichols. Christina Nichols with a C. File number is 251890LT. Mr. John Bradshaw is here on behalf of Vista Meadows. We were here last time. Mr. Bradshaw, you were here, and Chrissy Collins, your manager, was here then, and she's here now. We determined through November, the rent was $4,040, $198.40 in court costs, for a total of $4,288.40. You agreed you were going to move and turn in your keys. Have you been able to do that?
Well, like I said, everything's packed. I just was having a hard time getting somebody to go get it because I'm not in the same state. So I do have a friend that said she could do it today. Like today was her day off. She said she could get right on it today and get it. It's all packed. It just needs taken out of there.
Well, you get 10 days to move before they do the eviction.
Okay. So how many days do I have left? Is that starting last Friday or today?
Starting today.
Okay,
You have
yeah.
till November 24th.
Okay. And then as far as a forwarding address, can I give that to you guys now?
I don't want you to give it to me over the live feed. Everybody will know your address.
Oh, okay.
So you can call the management. You're supposed to give it in writing within 4 days of your moving. If I had access to the conference room, I think Judge Patterson's using, I'd put you in there. But anyway, what state are you in?
South Dakota.
My, they have snow on the ground there yet?
We did, and it's all melted already. So it's been 50s all week.
Same as here. All right, you have until, I see your judgment, November 24th to vacate.
Okay.
Now, there's no money judgment here. They may come at some point in a civil case to try to collect on your unpaid rent. But this is simply a possession judgment. Partial payment will not prevent the writ of eviction. When you move, you need to turn in the keys and give your forwarding address in writing within 4 days.
Okay.
So, but by law, they can't take any action until 10 days from today. Now, if you get out sooner, that's great for them. They can clean the apartment and re-rent it. They've got a waiting list. They've
Right.
got people ready and waiting to use your apartment, and now it's just sitting there with boxes in it.
Yeah,
So
no.
the sooner you get out, the sooner they can rent it.
The room is open.
All right, that's good to know. Thank you.
Okay.
All right, you have till the 24th also to appeal this.
Okay.
All right, thank
My
you.
next one's not till 9:10, so I'm
All
gonna do
right.
some other criminal.
Mr. Bradshaw's gonna go deal with some other matters, and we'll, all right, Ms. Nichols, best of luck to you.
Thank you.
You told me she's not sharing first.
All right, I got 3 people in the waiting room. Ms. Hines, why don't you come on up?
All right, Brandon.
We'll see who we've got. We may need to advise this group of people of their rights. Each of those was a second hearing.
Thought it was easier to come in person.
Yes, it is sometimes. You have cases behind us, or are you all
No,
done?
I'm all done with that contract.
All right, well, let's see who all we've got here. We've got David Misiak, who is our defendant in the next case. We've got a telephone number. Who's here by telephone?
Curtis Webb, sir.
What's your name?
Curtis Elias Webb.
All right. And we've got Mr. Havens and Miss Patinod here also. So for all of you, Mr. Misiak, can you hear me? Mr. Miziak, can you hear me? You logged in earlier, you were practicing, which I appreciate. I can see your name, but I can't see you and I can't hear you. Can you hear me? Mr. Miziak, you're our next case, so we need to bring you into the hearing. I lose a lot of time in my life doing this, but if we can get our rights done, we can tell 3 people all at once. Mr. Miziak. I'm gonna remove him, see if he logs back in. I can't hear you and I can't see you. So it's like you're not here at all. Try to log in again. All right, he logged out, but now I can't start until he gets here. But Mr. Havens, Miss Patnott, I appreciate you being here early. Mr. Webb, I appreciate you being here early. If I could get our next guy in here, we could start. Don't you wish you were back there doing criminal pretrials?
No.
Oh. Doesn't miss it a bit.
I walked in today and thought, oh, it's last
Yeah, you
pretrial
saw
there,
it.
is it first or second Friday?
Well, it's the 3rd Friday,
Third
but
Friday.
he moved it because of the holiday.
Yeah.
He logged in early, like at 7:15.
Well, he asked for an adjournment yesterday.
Yes. He said he would try to log in from his car. Mr. Webb, can you hear me?
Yes, sir.
All right, well, I'm gonna go ahead and advise the Patnod and the Haven defendants and Mr. Webb of their rights as a tenant, the landlord-tenant proceeding. You are a tenant in a landlord-tenant proceeding. In Mr. Webb's case, they're asking to pay the rent. In the case of Mr. Havens and Ms. Patnod, they're asking them to move out. In either case, you have a right to hire a lawyer. If you cannot afford one, a legal aid attorney may be available to help you, or you could seek other legal help. There is no court-appointed counsel for civil matters. You have a right to have the case heard here in St. Joseph County where the property is located. Here's Mr. Miziak again. Mr. Miziak, can you hear me? I tried to unmute him from my end. Mr. Miziak, can you hear me? All right, we're gonna just continue. All right, you have a right to demand a jury trial. If you want to have a jury trial, you must tell me, the court, at this first appearance, or be prepared to file a written demand within 5 days using the jury demand form and pay the $50 jury fee unless the court waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Department of Health and Human Services, Community Action Agency, or Neighborhood Inc. Or if you're a veteran, you may be eligible for some veteran services. We sent that information to you with the original packet. You do not need a judgment against you to get help from the places listed above. a copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that, the court can help set that up. And finally, if you can reach an agreement with the landlord, the council could prepare what's known as a conditional order of dismissal, which would show as a landlord-tenant case on your record. Mr. Webb and Mr. and Mrs. Havens, or Mr. and Mrs. Havens, your lawyers aren't here yet because we're a little early. Mr. Miziak's lawyer is here. His plaintiff, his landlord's lawyer, Mr. Lugie, they're ready to go. So Mr. Miziak, you're here, and I'm going to proceed as though you can hear me. This is a termination of tenancy case. There is no lease that I was able to determine here. I think the plaintiff purchased this at a foreclosure sale. Ms. Hines, what's the status here?
There was no written rental agreement since fall of 2021. My client agreed to lease 20 acres of land for Mr. Musiak's 11. At that time, there was 11 head of cattle, Highland cattle. He's now failed to really take care of the cattle. He's failed to pay any rent. He's allowing my client to do everything, feed them, give them hay, do everything necessary. So there are now still cattle remaining. There's 3 bulls, 7 cows, and 4 cats, 14 total head of cattle. That's on my client's land that belonged to Mr. Musiak, and we want an order of eviction because he can't keep caring for them at his own expense.
I understand, but I'm not sure this is the right, so I'm going to evict his cows. What are you going to do with them?
I mean, I guess.
Turn them loose?
Well, he's Mr. Lugie has a plan for the cows.
What's the plan for the cows?
Yeah, the plan is to sell as many as we can as quick as possible.
All right, let's assume that he had a house full of furniture.
That's how I explained it to my client.
And you filed for a writ of eviction. You don't just automatically get to sell all of his furniture. You get to remove it from your property. But it doesn't give you the right to his personal property. So
we'd like Mr. Musiak to come take them.
Well, if I could get him to speak to me. Now, he is here. So the law requires that I continue this matter for 7 days. It's not a default, even though I can't hear him or see him. He is here. This order, Mr. Miziak and Mr. Lugie, the law requires in a landlord-tenant case that you adjourn it 7 days, at least 7 days. It didn't used to be that way. But when COVID hit, all the rules changed. We started doing things remotely like this. And there were issues. The government justifiably didn't want a bunch of homeless people during a pandemic. So there became federal funding available to help people stay in their residences. And it slowed down. It took time to do all that. So the law requires now in all landlord-tenant cases that we adjourn it at least 7 days. So we have to do everything twice. Then after 7 days, he would get 10 days to remove the property. So 7 days from today would be next Friday, November 21st. 10 days from that would be December 1st. Mr. Miziak, you need to get a plan to get your cattle off Mr. Lugie's land. we're gonna continue this matter depending on Ms. Hines' availability. Let's take a look. How are you for the 21st?
And if Mr. Musiak could call me, I mean, I would appreciate a phone call to see if we can work something out. We've asked for supplemental damages, so that might require a future hearing.
Yes. Yes, he's now, this isn't great. There's no lease.
I know,
It's a handshake deal,
I get it.
which makes supplemental damages difficult.
But we have a history of paying rent and providing things. So
all right. So we would adjourn this.
what time on the 21st?
Boy, the day's full. How about 8:45?
That's fine.
All right, we're gonna continue this to 8:45. Now, here's somebody, let's see who this is.
Hello, good
Somebody
morning.
else is here by telephone. Who am I speaking with?
Good morning, Your Honor. This is David Misiak. I apologize for the technical
All right,
difficulties.
Mr. Miziak, did you hear everything we just said?
Only about the last 2 minutes that I missed. Everything else I had heard.
All right, here's the deal. They allege you've got 3 bulls, 7 cows, and 4 calves on his property, which is located here in St. Joseph County on somewhere,
Buckhorn Road.
Buckhorn Road. I drive past this all the time. He wants you to come get your cows and bull and calves off the property. They're also going to ask for some financial money damages. The law says we have to adjourn this matter at least 7 days. So we're going to continue this matter till next Friday, November 21st at 8:45. Do you have something to write with?
I do.
All right, I want you to write Ms. Hines's phone number down.
It's on the summons, Your Honor.
All right, it's on the summons to
I
Centerville.
have that.
It's actually a Corey Lake number in Centerville, but do you see it?
I do.
All right, I want you to call her. You can call her this morning. And let's see if you guys can work out some plan for this. Then nobody will even have to come back. But at some point, he's going to ask for money damages, even though there's no written lease. He's claiming that you owe money for tending and feeding and caring for your cattle. But the main thing is, these need to be dealt with. Now, maybe you'll just agree to let him sell the cattle and call it good. I don't know. But I want you to call Miss Hines and discuss this with her. Lori, potentially I could put you in the conference room. You guys could talk about it right now.
That's fine.
Laura, would you open the conference room for me? I'm told that Judge Patterson was not using it. So unless I hear otherwise, the matter's continued to next Friday at 8:45. You're all here. Mr. and Mrs. Loogie are here. You're here. Ms. Hines is here. I'm going to put you in a room privately. Your phone number hopefully will go in there automatically. And you guys can discuss the options to getting this cattle off the land. Is that agreeable with you?
It is, Your Honor, but I want to point out one thing, that in my last attempt to access the property, Mr. Louie called 911 and the state police responded and threatened me with trespassing. So I need to know that I will be safe as I work to resolve this issue with him.
All right, is that true? You called the cops when it came out there?
Yes, Your Honor.
Why?
There was an understanding. He knew he wasn't supposed to be there without me being there. and
Well,
he
that's
showed-
not a tenancy. If he's a tenant, he can come and go. You don't have to be there.
He had to protect his own cattle,
Well,
so,
this isn't a
Yes.
landlord-tenant case. This is something else.
well, but
If
we
he's a
can make
tenant, he's got
arrangements.
the right to go on there whenever he needs to. And you can't call the police when he shows up. So let's see if you guys can come up with a solution.
Thank you.
So I want you to go in what's called the Zoom room. You spelled it wrong, but and then we'll set up a breakout room. You guys can talk about it privately.
Sure.
Hopefully you can come up with an answer and we won't have to come back. But if we do, it will be next Friday morning at 8:45.
Very good. Thank you.
All right, thank you.
Thank you,
All
Your
right,
Honor.
Mr.
I'll stay on
Misery, stay with, hopefully we'll go into this automatically. Zoom room and the phone number. Right on this side. Mr. Webb, Mr. Bradshaw's caught next door, so I'm going to jump ahead one case. I'm going to call the case of Village Manor versus Mary Pattinaud and David Havens. Are you Mary Pattinaud?
Yes, sir.
And you're David Havens?
Yes, sir.
Of course, I know you both, but I need to identify your record. Ms. Haddad, could you join us, please?
Yes, Your Honor. Just a second.
Are you in another court? at
I
the
am.
same time?
I'm in between. I'm in between courts, Your Honor. Let me just.
All right, I guess we'll wait for you to finish your other matter.
That's okay. We can call it, Judge.
All right, well, you sound like you're at the bottom of a well, and I can't see you. So, could be better. But this is a termination of tenancy matter. Oh, you're in your car, okay. And they're asking you to move for a number of alleged lease violations which contained in a letter of September 19th. What's your position? Are you willing to move or do you wish to stay there?
Your Honor, as I very well know, they want us gone. We had a wonderful, great relationship with Village Manor and Lori Cousineau, and we've been there 5 years. But we can't fight it, so we do got to go. We've been looking. We have we're on waiting list for numerous apartment buildings and stuff like that. But there's just nowhere to go right now. So I know this is by law. You're going to do us 7 days. We're hoping and praying for the best.
Well, all right, let's talk a little about that. The law does require that I adjourn this 7 days, and then you would get 10 additional days from that day to move. Normally, a legal aid attorney would be here with us, Meg Bauer. I think she's off starting today for a week or so. So there's no legal aid attorney. Normally one would be here. So you may have some defenses, I don't know. But if you get evicted from subsidized housing, it makes you ineligible to get into other subsidized housing.
Yes.
So what this case calls for would be some sort of a conditional order of dismissal, that you could work out some sort of an agreement with your landlord and the council to vacate. But what you're telling me, I hear every single day, I would move if I had somewhere to move to. And if legal aid was here, they could perhaps assist with this. This law firm does a lot of landlord tenant work all over the state, and they know what a conditional order of dismissal is. But you are right. The first step we do is adjourn this a week. And a number of things in the letter, including unauthorized tenants and some other things, would be violations of the lease. You could have a hearing on it, but ultimately, if they prevail, you're right, you'd have to move. And you're not unwilling to move, you just can't find somewhere to move to. How much is your rent?
$746.
All right, that's less than market rent, but you're gonna be hard pressed to find something for $746.
Yes.
There's a few things out there.
Things were great Just, we had a neighbor issue and it just got ugly the last year and yeah, it was just, yeah, a battle.
When Miss Cousineau left and now she's somewhere else.
And it led to a lot of household tension between Mary and I, and it just got ugly, sir.
Well, I'm sorry to hear that. All right, Miss Haddad, does morning work better for your firm for next week?
Your Honor, we can make ourselves available whenever the court is scheduled.
All right, let's continue this to 10:15 on Friday, November 21st.
Your Honor, did I hear you correctly? Mrs. Cousineau is no longer with Village Manor?
I don't remember. She changed complexes. Maybe she went from a complex to Village Manor.
Okay, yeah, that's why she was Riverside. Now she's
All right, 11, 21, 25 at 10:15. Now, what I would suggest is you talk to your manager and discuss perhaps a conditional order of dismissal whereby you would agree to move by a certain date and they would agree to dismiss the case. At this point, they have not asked for money damages. They just want you to move. But if you do get evicted, it could make you very difficult to get in the next place.
yes.
So my suggestion, you may also wish to call legal aid. They're not available today. We gave you their number.
Yes.
But it sounds like you're agreeable with moving. And if we can get a conditional order of dismissal, that can be discussed.
So when we want to avoid that eviction surge, because like you said, it would be very difficult to find other housing if that was to take place. So we come back in 7 days and then.
All right, then I would give you 10 days from that day to move out.
If we got out before those 10 days, we can avoid the eviction.
Potentially, yes.
And then.
So that would be my suggestion. Now here's, maybe this is Miss Cousineau. I jumped ahead of a case, so
I like getting here early.
Mr. Bradshaw's in 2 rooms at once. Miss Haddad's in 2 courts at once, or 3 or 10, I don't know. Miss Haddad, where else are you appearing this morning?
36th District Court, Your Honor. I'm actually in the parking lot.
All right, which is a whole different world.
Yes, it sure is, Your Honor.
That's Detroit.
That's
And they
a
have thousands
euphemism.
and thousands.
That's right. That's a euphemism, Your Honor.
All
Or,
right.
yeah.
All right, we're going to continue this to November 21st at 10:15 a.m.
Your Honor, may I make a suggestion? I would,
Yes.
in the interim, I would suggest that the defendants reach out to Attorney Bouchard's office. And if they plan on vacating, then they just need to make sure they turn in their keys. Otherwise, the case does not get dismissed. And then, I mean, if they could ideally vacate before the next hearing, we'd be more than happy to dismiss the matter.
All right. Did you hear that? If you can vacate before the next hearing, which may be a lot to ask for doing in 1 week. But if you can vacate, when you do vacate, you need to turn in the keys and give your forwarding address in writing within 4 days. Now, the number of the law firm is on the summons. They're in Bingham Farms, 248-731-7810. It's right there on the front page.
Gotcha.
You reach out to them and discuss the terms, and if you can agree to vacate, they can agree to dismiss it. Ms. Cousineau, are you here?
Yes, I'm here.
All right. We started a little early. They said nice things about you, by the way.
Oh, nice.
Anyway, they're going to attempt to vacate in a timely manner and seek a conditional order of dismissal. So they may be contacting you. They're also going to be contacting the Bouchard Law Firm directly regarding that. So unless I hear otherwise, the matters continue to next Friday, November 21st at 10:15. You can talk to your manager, but preferably go directly to the law firm and discuss this with them. All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
All right, good luck to you, sir. Mr. Webb, Mr. Fleeman was or Mr. Bradshaw was here, then he was out. Ms. Haddad, good luck there in Detroit.
Thank you, Judge.
All right. All right. Thank you. Good luck to you. So we're waiting for Mr. Fleeman. We've got Stacy Ames present. Her matter set for 9:30. Miss Ames, can you hear me? I'm having trouble today. Miss Ames, can you hear me?
Yes, I can, Your Honor.
All right, I'm going to take a minute while we've got some dead air here and advise you of your rights as a tenant in a landlord-tenant proceeding. Your landlord wants you to move out. It's called a termination of tenancy. It's a Swan Street house in Colon. You have the right to hire an attorney. You cannot pay for one. The court will give you information about getting an attorney from legal aid if you're eligible and if they can assist you. Otherwise, you can seek other legal advice. You have a right to have your case heard here in St. Joseph County where the property is located. You have the right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or be prepared to file the demand in writing within 5 days and pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, that doesn't apply in your situation. They just want you to move. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested in that, the court can help set it up. Or you may be able to reach an agreement with the landlord that means the case would get dismissed by the filing of what's called a conditional order of dismissal. So let's wait a minute while we see for Mr. Webb to show, Mr. Carr to show up. I'm waiting for Mr. Bradshaw to show up. Mr. Webb will address your case as soon as we can get the parties lined up. I appreciate your patience.
No problem, sir.
Good morning, folks. Which case are you here on?
The rental eviction of Ivan Earlinson and Jennifer Green.
Very good. Thank you. Just have a seat. Have to remove your hat, sir. Thank you. All right, we're in hurry up and wait mode. Good morning, sir. What's your name, sir? Is that Ivan Earlinson? What's your name, sir? Are you Roger Carr? Yes. Why don't you have a seat right there, Mr. Carr? I remember you. Can you hear?
My hearing is not good.
All right, just a moment.
Mr. Carr, you need to take your hat off.
Have a seat for a minute. We'll get you hooked up with the headphones. Mr. Bradshaw, Mr. Webb is ready. And she'll tell you what to do. Have him take off his hat.
Okay, thank you.
All right, Mr. Webb, can you hear me?
Here, so you should be able to hear.
Yes, sir.
All right, Mr. Bradshaw is here. I have advised him of his rights as a tenant.
Can you hear anything out of there?
This is filed as a demand for non-payment of rent. We did have some previous cases. Mr. Bradshaw, what's the current status?
Yes, sir. The current amount due through the month of November is $865 in rent, $183.28 in court costs, for a total of $1,048.28. As always, I'm more than happy to do a conditional dismissal or a judgment, whatever its preference.
Mr. Webb, what's your position?
I am actively trying to pay this as we speak. I have been having a hard time finding work. I was able to pay the previous 2 months of rent I owed. I did a bunch of odd jobs to pay it, so I'm still trying to pay the rent. I would like to stay here if possible, so I Joyce didn't do, so I will try to pay it.
All right, well, the law requires we adjourn this matter 7 days, which would take us to next Friday, the 21st. Then you'd get 10 additional days from that day to pay the rent, which would give you time to get caught up. Let's look at what next Friday looks like. Mr. Bradshaw, I don't see that you're here next week.
No, but we don't have a lot. We can zoom in. That's not a problem.
All right, how about 10:20?
10:20. If it's possible, can I give him my direct?
Yes,
Mr. Webb?
just a minute.
Oh, sure.
Yes, sir.
All right, you can call Mr. Bradshaw and discuss this with him. They could do what's also known as a conditional order of dismissal. You have something to write with?
1 second, sir.
All right, his number is also on the pleadings, but write this direct number down.
Mr. Webb, it's area code 269-569-7590. One more time, 269-569-7590. Give me a call and we'll see what we can do between now and next Friday.
All right,
Thank
now,
you.
if a matter is resolved, you don't need to be here next Friday. If it's not resolved, we'll make a record next Friday at 10:20. And if necessary, then you'd get 10 additional days to pay the rent or move. And do you have any questions?
No, sir. Only when are you available to call, sir?
When will you be available for the call?
This afternoon.
He'll be in this afternoon. He's here with me and our other judge this morning. He'll be back in his office this afternoon.
All right, with 12:30 work?
Okay, very good. All right, like you're working on it, can be resolved. If it is resolved, I won't see you. Thank you for coming early and thank you for.
Thank you, sir. You have a good day.
Thank you. Thank you, Your Honor, for the.
All right, is that finished for you,
It
Mr.
does,
Bradshaw?
yes, thank you.
All right, thank you. Let's see who I've got here. Somebody's here by telephone. Who am I speaking with?
John Barnes?
All right. Mr. Barnes, you're John Barnes Jr.,
Correct.
is that correct? But not
Yes.
our John Barnes, but someone with the same name. All right, you're in the right place. I don't like doing this by phone only, but sometimes you have to do what you could do.
My computer's
Did you
not
find
really
anything that
dependable.
worked?
Yes, sir.
All right.
He's got one.
Mr. Carr, would you come up and have a seat right here, please? And Miss Ames, can you join us?
Yes, Your Honor.
Good morning, sir. You Roger Carr?
I am, thank you.
It's been a number of years since we've had business, but at one time you were the county drain commissioner. Is that
That's
correct?
right. We went to a circus.
You went to a circus.
Isn't that right?
Well, maybe so. Anyway, this is a tenancy at Swan Street in Colon. There is no lease. I'm not sure what the status here is, but you wish Miss Ames to move out, is that correct?
That's correct.
Miss Ames, what's your position?
I am currently, Your Honor, in the process of moving. My issue is not getting things out of here fast enough because I don't have the physical ability to. I'm here with my 2 children. I don't own a truck. I have to wait for my ex-husband to borrow or have him help us move the larger stuff.
Do you have a place to move to?
As of right now, I and my children are going to have to move in with my ex-husband.
What town is that in?
Leonidas.
Well, the law says I have to adjourn this matter for 7 days. I explained some of that earlier. After COVID, they changed the landlord tenant rules. So that would take us to next Friday, November 21st at 10:30.
Okay.
Then you would get 10 days from that day to move out, which would be by December 1st. Do you think you can move by December 1st?
Your Honor, we don't have a choice. It's 63 degrees in my house right now. We have no heat. None.
Why not?
The furnace has not worked. We're heating our home with our stove and 2 space heaters. We've had to block off most of the house just to try.
That's very dangerous. Well, he's not at this point asking for money damages. He's simply asking you to move. How much is the rent each month?
$800.
In Three Rivers or Sturgis, you couldn't rent a house that the furnace doesn't work. But they don't have a lot of zoning enforcement in the village of Colon. Anyway, Miss Ames, if you would simply agree to move by December 1st, we wouldn't even need to come back. Is that agreeable with you?
Absolutely, Your Honor.
Is that agreeable with you, Mr. Carr? All right, Elaine, would you prepare me a judgment? Maybe I have one and I'm not seeing it. Yes, I have one, thank you. All right, I'm going to show by consent that the defendant agrees to vacate on or after December 1. Now, Miss Ames, at this point, he's not asking for any money damages. He's simply asking that you move out. When you do move out, you need to turn in your keys and give your forwarding address within 4 days of moving. No money judgment is entered at this time. Now, this is a consent. You agreed to this. And the law says that under MCR 4.201J, that you do have 5 business days to change your mind. And you have to let the court know if you thought you didn't fully understand everything or you were compelled to do this against your will. You have until November 24th to appeal this. So if you move out by December 1st, turn in the keys and give your forwarding address, this matter is over with. If he asks for money damages, we'll do that at a later hearing, but I would reduce the damages by some amount because the furnace doesn't work. Do you have a security deposit?
I don't believe so, Your Honor, no.
All right. Are you related?
No, Your Honor.
Mr. Carr, I suggest if you're gonna be in the landlord business, that you at least get a lease. You can't rent this house out if the furnace doesn't work. But she's agreed here to move out by December 1st. You don't have to come back. She doesn't have to come back. If she does not move out, you can come back to the court and bring $15 and ask for a writ of eviction. And if she doesn't move, the sheriff will come put her out. But she wants to get out of there. Now, when she shuts off the stove and the space heaters, your pipes are gonna freeze. So as soon as she gets out of there, you need to get in there and make sure there's some heat. Miss Ames, I think this actually is for the best, and you need to get out of here.
Yes,
So you
sir.
don't need to come back. We won't have a hearing. You still got the Swan Street address, and I will send you a copy of that order. Mr. Carr, you now live in Litchfield?
Yes,
That's Hillsdale County?
yes.
All right. What's your plan for this house on Swan Street?
As soon as she's out of there, I'll winterize it and, or go to work on it, one or the other.
All right. Miss Ames, do you have any questions?
No, Your Honor, I don't.
All right, Mr. Carr, if you go out to the counter, you can just leave that here. They'll give you a copy of this order. If she doesn't move by December 1st, on December 2nd, you can ask for a writ of eviction. You have any questions?
No, no.
All right, you're good to go.
Thank you, Judge.
Miss Ames, good luck to you.
Thank you, Your Honor.
All right, when I was prosecutor, Mr. Carr was drain commissioner. We did work on some cases together, but I haven't seen him in many, many years. All right, Miss Ames, you're good to go. And let me remove you.
Thank you, Your Honor.
All right, good luck to you. I think you need to get out of there.
She take the check.
You can have that badge. Who's this?
That came in by email from lady in California.
Oh, someone tells me that I'm wrong about this. It is against the Fair Housing Act. Well, we'll see.
And then there's 2 attachments to that.
We haven't made a ruling yet. We did. All right, so I guess we'll see. ESAs are exempt from pet housing fees. Oh, I may have to have a rehearing. Thank you, Ms. Robledo. No one's ever raised that defense. If Meg Bauer was here, she probably would have raised it. Thank you for that. Don't let Mr. Bradshaw leave. I need to see him before he goes. Do you know who he is? He's the older attorney with gray hair. He's here for Casey Strong. He's been in and out of here and Judge Patterson's courtroom. Yeah, John Bradshaw, blue suit, gray hair. All right, thank you. Bye. All right, thank you for that from one of our viewers. Federal law always trumps state law, even in the landlord-tenant arena. So we may address that further, but let's talk about who we've got here. We've got John Barnes. We've got Ivan Earlinson. And I'm going to advise Mr. Earlinson and Mr. Barnes of their rights as a tenant in a landlord-tenant proceeding. you each have a right to hire an attorney. If you cannot afford an attorney, the court must give you information about legal assistance. Normally our legal aid attorney is here, but she's off this week and next week. But you can contact legal aid at the number we provided. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or be prepared to file a written demand within 5 days and pay the $50 jury demand fee unless you are unable to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from, Mr. Bradshaw, would you take a look at this? Department of Health and Human Services, local coordinated entry agency, housing assessment and resource agency, or a federal help for homeless veterans program. You do not need a judgment against you to receive the help from the places listed above. Copy of the summons and complaint are sufficient. You may be able to reach an agreement outside of court resolving the case, which means it could be settled with a conditional order of dismissal, or we would need to perhaps send the case to mediation. If both parties are interested, the court could help settle that. So it appears we've assessed her for a pet fee, and if it is a certified ESA.
Correct. So as she was saying that, I realized probably what had happened, because there's nothing in my file to confirm that she's actually supplied or applied for an ESA animal, which is to say she would need something from the her healthcare provider stating that she needed this particular animal. I think probably, and this happens a lot, I think what probably happened is that she said, I have an ESA, and they told her, well, please provide the documentation. It wasn't provided. And therefore, that's why they're considering it still a pet. I was going to talk with you at some point about that. If she does have a doctor's statement that she needs this animal as an emotional support animal, then we cannot charge a pet deposit. We can't charge an ongoing pet fee because it's no longer a pet. It's an emotional support animal. So I think this morning, without that documentation, just her statement that she told somebody that she had an ESA is not sufficient to state that she has an ESA.
Well, Lori was in on, we should explore that further. I don't know how many $30 pet fees make up that $657 rent fee.
I can check that out.
So if I can't assess it, and it is true, people will put a vest on an animal and call it an emotional support animal.
Correct.
And as I said, everything from a pot-bellied pig to we have a guy here that just went through that. But I was in error when I said that the lease controlled, because federal law supersedes state law.
If in fact she's provided that documentation, that would be correct.
All right, so that may be an issue we'll need to explore. If she has it, before I do any writ of eviction, in that case, I'd want to make sure what those numbers are.
Absolutely. So what I'll do, Your Honor, is I will go back and say, and ask my client, if she does in fact have that documentation for an ESA, then I'll withdraw all of those pet fees from that she's paid, and I'll submit an amended judgment, and we'll go from there.
All right. Hopefully it won't come to a writ of eviction. Before I ever sign one, I'll make sure I've got the numbers right.
Absolutely.
All right, thank you. And thank you to that viewer. I'll make that part of the file. Would you like a copy of that?
Sure. Have somebody send
All
it.
right.
Thank you.
Okay. Are you done here in Centerville this morning?
Oh, no.
Oh, all right. Thank you. All right. Good morning, Mr. Rognes. Is Monica Bonsler here? All right, that matter is set for. Let's see here what I've got. Moninda Bonsler. Is Moninda Bonsler here? All right. Well, Miss Bonsler, you have a seat on this side. Mr. Earlinson, you have a seat on this side. Have a seat right over here, sir, if you would.
I'm her son. That's my
Oh,
son.
that's you're not Mr. Earlinson.
No.
Okay, you told me you were here, so I misunderstood. I thought you were here. Have a seat. This is set for 9:40. It's 9:49. All things considered, we're not doing too bad. It's entitled Melinda Bonsler versus Ivan Earlinson and Jennifer Green. This is a property on Diane Drive in Constantine. Everybody's in the same house.
Everybody's in the same house.
Who are they to you?
He and his, well, actually his granddaughter, Tiara, were clients of mine. They have been clients.
What kind of business?
Doing tax returns, payroll, bookkeeping, but only thing I've done for them is tax returns in prior years.
Now, the Ivan Earlinson I'm thinking of is in his early 70s. Is that him?
Correct.
Okay. So he's living there. There is no lease.
We did not have a written lease. We only had a verbal agreement, which he has not even kept the amount he said he would pay with that every week. He said he'd pay me the same thing he was paying at the hotel where he was staying, but he has not done that.
How long's he been there?
Way too long. I think it was around July, around 4th of July. I'm trying to think how many years ago. It's been at least 3 years or longer, 3 or 4.
All right. Well, he has no lease. He's not paying rent. Who is Jennifer Green?
Jennifer is his daughter. She moved in probably over, I think it was about 6 months or so, approximately 6 months after he did. And when she moved in, she brought 2 pit bull dogs with her. They have never paid me any deposits for any dogs, let alone any monthly payments for the dogs.
Oh, you don't have a lease, so you don't have a dog fee or anything, but they're tenants at Sufferts, and they aren't here. They've been personally served with this matter, and I have 10 days to move out. I wouldn't have pit bulls in my house on a bet.
They're in my garage right now, and every time we walk into the house, we're dodging either poop from the dogs or their pee most of the time because they're not taken out like they should be.
All right. Well, they have 10 days to move out. November 24th.
Okay.
Now, if they don't move out, you can ask the sheriff to put them out, including the dogs.
Don't want the dogs at my house.
Well, this goes under the category of no good deed goes unpunished. You let him move in, then you let her move in, and you didn't have a lease, then you let the dogs move in. They've been personally served according to the proof of service. And they aren't here. And when you're personally served and you don't show up, you're subject to default. I'm surprised you let them stay there this long.
I had asked them to leave probably over 2 years ago. And they kept saying they couldn't find a place, And, maybe it was because of the pit bull.
Well, no one wants somebody to move in with 2 pit bulls, but there's nowhere to move to. So that's why we have this, people would say, I'll move when I find a place. 9 years later, they're still there. This broaches the issue. If they don't move, the sheriff comes and puts them out. Do you know why they're not here?
I'm not sure why Jennifer is not here. I know Ivan works at, what's the name of the place? Ox Engineering in Constantine. I don't
Well,
know.
that's not an excuse for not showing up for your court hearing. All right, you can go home and give them a copy of this. They got 10 days to move or they're subject to being evicted. You bring $15 and they'll do a writ of eviction and the sheriff would put them out. It probably would not happen until after Thanksgiving. You don't have to ask for the writ on November 24th. You have 56 days from today to ask for it. But if you wish to ask for it on the very first day, you could ask for it on the 25th of November.
Okay,
So if you go out to the court office, the clerk will give you a copy of this and an extra copy you can take home for them. They got 10 days to move or the sheriff's gonna put them out.
okay,
All right, you're good to go.
thank you.
All right, thank you, Mr. Reed, Mr. Rognus, Mr. Kreitz. Mr.
Your
Reed,
Honor.
Mr. Barnes is here
Okay,
and he has been advised of his rights as a tenant.
okay.
This is file number 252087 LT. Timothy Reed is here on behalf of the city of Three Rivers. Mr. Barnes is a resident at 509 Spring Street. Mr. Barnes, can you hear me?
Yes.
And this goes with, no, I need that. This goes with the lady with the dogs and send a copy of that to Mr. Bradshaw.
Okay.
I think
sure
we'll
will.
address that.
Thank you.
All right, Timothy Reed for the plaintiff, John Barnes by telephone. What this looks like is the city of Three Rivers bought this house at a tax foreclosure sale in some time ago in July. They served a notice to quit on the defendant in August and he's still there. Is that correct, Mr. Reed?
That's my understanding.
Mr. Barnes, the city of Three Rivers wants you to move out. What's your response?
Yes, sir. I've got most of my stuff out of the house in storage, and I'm trying to find an apartment. Nothing comes open.
Yes. I've heard that a lot, even today.
I'd like to get somewhere close to a grocery supply. My truck's 1995 truck. One little thing go wrong with that, and I'm without a car. So,
Well, the law says I have to adjourn this matter for 7 days, which would take us to next Friday. November 21st. Does 10:40 work for you, Mr. Reed?
That should be fine, yes.
Then you'd get 10 days from that day to move out. So right now your house payment is 0. You're not paying any rent, you're not paying the taxes, and the city of Three Rivers owns the house. Are you paying the utilities and water?
yes.
I can't picture this house in the 500 block of Spring Street. I probably drive by it all the time. But at this point, it's been sold at a tax foreclosure sale. The overage from the sale would go to you or whoever the owner of the home is.
He never filed an affidavit of claim.
All right, so you never claim the overage. I know a lawyer that knows how to do that stuff, but he came down and tried to instruct the members of our bar and provided some very helpful information upon the request of Attorney Rognus. But anyway, Mr. Barnes, you're between the proverbial rock and the hard place. You're gonna have to get out of there by the 1st of December. They're gonna file a writ of eviction and compel you to leave. But for now, we're gonna continue the matter until next Friday at 10:40. You can call Mr. Reed's office and discuss this with him. If you can agree to move voluntarily, perhaps they could do a conditional order of dismissal. But if you're looking to get into assisted or subsidized housing, an eviction could be very damaging. And you're right, there isn't anywhere to move to. Everybody would move if they could. And, but there's no easy place to move to, especially when your rent is currently zero. How long have you been there?
About 50 years.
Wow. Anybody else live there?
My son will live there.
All right, well, this applies to you and all occupants. I should know who you are if you lived in Three Rivers for 50 years, but I can't place you. But this is a tough situation. So you can call Mr. Reed and discuss it with him, or we can address it further next Friday at 10:40, just like this.
Okay.
Do you have any questions?
Not really. I need to get going. 50 years here, and I'm not real familiar with doing this.
Yes, it's a tough situation. I'll just leave it at this. Anyway, the city now owns the house. Mr. Reed is the attorney for the city of Three Rivers. I encourage you to perhaps discuss it with him. Otherwise, we'll be back here next Friday morning at 10:40, just like this. All right, sir, you're good to go.
Thank you, Your Honor.
All right, thank you. I wish you luck. It's a tough circumstance. We had another one on Spring Street where somebody had been there for a number of years, 17, was a faithful tenant. The landlord wanted to sell the house. She couldn't afford to buy the house. And so they had to move. All right, Mr. Reed, I think you're good to go.
Yeah, I'll see you this afternoon. I think I have one at 3 o'clock.
All right, very good. Thank you.
Thank you.
All right, Mr. Rognus, let's bring in Samsung.
I think that's speakers. I think that's who it was last time.
Yes. Good morning. Are you Jeremy and Brandy Baker?
Yes, we are.
Yes.
All right, we return. Hey, we're right on time. It's 10 o'clock. We return to Monroe and Vicky Learn versus Jeremy and Brandy Baker. Mr. Andrew Rognus is here on behalf of the plaintiffs. The Bakers are here. They are living in the house at 503 West Michigan, a big old stately home in its day. We determined what the arrearage was on the land contract last time. Mr. Rognus, has anything changed since then?
Not that I'm aware of, Your Honor, and I had emailed the Learns earlier this morning with no response from them that any payments have been made, so I guess we go forward with the numbers we had last time. There is a 90-day redemption period on this. It's not been paid. I mean, it was 200,000 balance after the down payment, but they owe at this point in time a loan payoff of 197,667. So they're not even close to being halfway home.
What that means, Mr. and Mrs. Baker, if you have a land contract and you're buying a house for $100,000 and you've paid $20,000, you get 90 days to redeem it. If you're buying that same house and you've paid $60,000, which is more than half, you get 180 days to redeem it. So in this case, we get 90 days from today to redeem the property. Now, let's take a look. I wrote this down.
Like
The
Valentine.
current arrearage is
For the monthly payment.
is $3,900, $196 in costs and unpaid taxes in the amount of $3,708.27. Is that correct, Mr. Aragnes?
3,709.27.
709, I wrote it down wrong.
Yeah.
Mr. and Mrs. Baker, this would give you 90 days to try to either catch up with this or get conventional financing. Do you think you're gonna be able to catch up on this?
Most definitely. In fact, I've tried to reach out to Monroe and Vicky. I did finally hear back from Vicky last night, and then I sent another text, and that was kind of the end of the conversation. So I'm confident that not only will we catch up, but that we'll be able to somehow get in contact with them and work it all out.
All right, very good. All right, I find that the amount through now each month will continue to occur.
Mhm.
3,900 in rent and payments, at $995 per month. 3,709 in taxes. $0.27 and $196.75 in cost for a total of $7,812.02. You have 90 days to redeem that.
Okay, I'm sorry, can you say that amount one more time? 7,000?
$7,812.02.
Okay.
And you do have 10 days to appeal this, which would be 11/24/25.
Okay. And
All right.
not that it makes a difference here or there, just when it comes to the taxes, I mean, when we made the land contract, of course, we were aware that the taxes would be coming to us, but because of the paperwork and filing and whatnot, it never got transferred to our name. We got the notice and it was literally due a week later by the time we got the notice, which is why it was so far behind and wasn't paid. We didn't even know about it until a week before it was due.
Well, that's why land contracts are different than leases or rental agreements. You get 90 days rather than 10 to try to get rectified because you have an actual interest, equitable interest in the property. And so it sounds like you're on good terms with the Learns. The Learns would like to complete this land contract. You'd like to complete it. So both people are trying to reach the same goal. But I'm going to send you a copy of this judgment. And certainly the Learns can be hard to contact sometimes, but stay in contact with them. Even then, they don't have to evict you on the 90th day. They would have 56 days from that day to ask for the writ. So there's more than 100 days to try to get squared away on this. So I'm going to send you a copy of the judgment at the West Michigan address. And good luck to you.
Thank you.
Do you have any questions?
No, sir.
No, thank you.
All right, stay in contact with your seller. Thank you, Mr. Agnes. All right, Mr. Bush is here, Mr. Kreitz. Oh, there they are. I couldn't see them. Good morning. It doesn't mean anything. I don't even know what to make of it. But anyway, Mr. Kreitz is here. Mr. Bush is here. This is a second hearing in the matter of Jamie Kreitz versus
It's actually Larry Kreitz.
no, Larry Kreitz versus Elisa Ferris Laffler and Josh Laffler, I think. We were here last time Uh, Plaintiff wants to terminate the tenancy. He indicated he wanted a jury trial. And he was mad at Larry, and they were put in a breakout room for a while. And he said he paid $10,000 to Larry, and then he got a notice to quit. Well, now he isn't here. This matter is set for, oh, it's not 10:15 yet, so we can't call the case yet. Somehow we got caught up.
Can I have it's a handwritten, but I have a payment schedule, if I could present that.
Yeah, that'd be helpful.
This does show that they did get caught up in
June 26, 25. Are you done with your criminal cases this
Yes.
morning?
Mhm. Next stop to jail.
All right. All right, the morning has gone relatively smoothly. I thought I was kind of a visitor this morning from Jackson. I've yet to see him.
Morning, Jamie.
Morning. So we have a 10:15. And then we don't have another one until 11:15. And we had an 11 o'clock case, which I believe has been resolved. So after this hearing, we'll take a recess. Maybe I'll take a cold pill and try not to. My computer wanted to update right in the middle of our proceedings here. I guess we'll wait. So, Mr. Bush, you're saying they got caught up on at the end of June and then they stopped paying after that?
Yes, and then obviously we sent a notice to quit, so we couldn't accept any money.
I
I don't know if they even told me
okay.
after that. The notice to quit was dated.
Here's you write it down. 8/25.
I think it was on 8/5, not 8/25.
Okay.
Jimmy, is there any movement of foot? Look like they're moving or anything, or?
Be honest with you, I haven't drove by, John.
At 10:13, we got 2 minutes. I fully expected them to be here. They were quite involved last time. Here he is. Good morning, Mr. Ferris.
Good morning, Your Honor.
Is Miss Lafler there also? Oh, here she is. All right, we're going to return to the matter of Larry Kreitz versus Josh Ferris and Alyssa Ferris, Lafler. Both defendants are here. I had advised them of their rights last time we were here. We were here on November 7th. We determined there was a arrearage in rent, but more importantly, the landlord wants to terminate the tenancy to have the defendants move. The arrearage was substantial. In June of 2025, the defendants sold a car and paid a substantial amount of rent. And according to Mr. Bush's records, as of June 26th, it appears that they were current with their rent. Then they didn't pay after that. And so Mr. Kreitz served a notice to quit on the defendants on August 5th. And here we are all the way into November. Once they serve a notice to quit, they can't accept any rent. So Ms. Ferris and Mr. Lafler, or Mr. and Mrs. Ferris, they want you to move. They're not asking for money right now. They're simply asking that you vacate. Have you had any success finding a place to move?
Yes, we have.
Very good.
We found a place, but it's not gonna be ready until the first week of December over in Three Rivers. So,
Mr. Kreitz, are you willing to give them until December 5th to vacate?
Yeah, we can do that, Your Honor.
Mr. Bush, do I have a judgment?
You know, I'm not sure. Typically, I send one over. If not, I'll give them over to you on Monday.
Yes, you do. If I don't have one, I'm gonna ask. Elaine, could you make a judgment for me in Kreitz v. Lafler? Normally John gives me one, but I don't see it. All right, Mr. and Mrs. Lafler, he's going to agree to give you until December 5th to vacate, which normally the date would be November 24th. So it's about 11 additional days. December 5th is the Friday of the first week of December. Can you vacate by that time?
Yeah, that should be fine.
Yeah, most definitely.
When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. He has not, at this point, asked for any money damages. If we're gonna sue for money damages, we'll have a separate hearing. People will be placed under oath. We'll try to determine how much the rent is, how much the security deposit is. Are there utilities owed? Are there damages? Should rent be abated or reduced because of other issues? So you're consenting to vacate by December 5th, which means you've consented to a judgment. And if you have the right under the court rule to have 5 business days to change your mind if you felt you didn't understand the proceeding or you were compelled to do this against your will, but I think you're both agreeable. Now, so you're gonna move to Three Rivers?
Yes.
I don't want to know the address, but when you do move, you need to turn in the keys and give it a forwarding address within 5 days or 4 days of your moving. Mr. Kreitz, any instructions on what to do with the keys?
They could bring them to my office, Your Honor.
All right. Certainly, if you're out sooner than that, great. If you can be out by before the 1st of December, that would be good. That would But every week that you're there would be another potentially unpaid week of rent. Elaine, I don't know if you heard me. If you could bring me a judgment in Kreitz v. Lafler. Do you have any questions?
No, Your Honor.
All right, let me repeat. You're gonna vacate by December 5th, or you'll be subject to being evicted. You have 10 days from today to appeal this, which would be until November 24th. There is no money judgment issued at this time. It's simply a possession judgment. So hopefully this will work. You can get your new place in Three Rivers, and there won't be any writ of eviction. All right, thank you. You're both good to go. Thanks for being here on time.
Thank you, Jamie.
You're welcome.
Thank you, John.
Can you hear me now?
Yes, now I can.
All right, I unmuted your microphone. Do you have heat in your unit? It looks like it's cold.
It is kind of cold in here, but yeah, we have heat. It's just the bedroom don't get heated that good.
All right, well, you have a seat. We'll be with this in a minute. This is entitled John and Lindsay Fitterling. Is John Fitterling there?
He is not.
Does he still live there?
He does.
Who's next? Oh,
This is filed as a demand for non-payment of rent. At the time of filing, it's alleged to be quite substantial, $7,580. Mr. Berlin, what's the current status?
Thank you, Your Honor. Yes, there's been no rent paid since July, so the rent to retain possession is $7,580. There's other money due, which consists of pet fees and utilities totaling $859.71, and then court costs of $282.20. So the total amount for a possession judgment would be $8,821.91. We're also seeking a money judgment here. The total prorated damages for rent through today's date for November, plus all past due rent prior to that, is $7,718.54. Court costs are the same, $282.20, and so the total money judgment is $8,074.
Miss Fitterling, what's your position?
I have paid all past due rent as of late last night.
Okay. Through a payment portal or something?
Yes, on the portal.
I think that being the case, Your Honor, I'll obviously need to confirm with my client, and given the amount, we'll want to make sure that everything clears. If we could maybe set this for a second hearing in a week or two, that should give us time to.
Yes, the law requires we set a second hearing. And so let's take a look at that. Today is the 17th. I won't be here on the 24th. So that extends us out to Monday, December 1st. We could do possibly no, we don't have a date until November 1st, December 1st. How about 2 p.m. on December 1st?
That would work for my schedule, Your Honor.
That works for me.
Now, Miss Fitterling, there are some other things in here that were not rent. Pet fees and utilities was alleged to be $859.71. Also due are court costs of $282.20. When we return, December's rent will be due. And these rents are substantial, $1,865. They're among the highest rents that we have. What is on Mackenzie Street? Is it a housing development?
Yeah, the duplexes.
All right, are these Edwin Allen homes or Allen Edwin homes?
It's through Copper Bay.
All right. All right, let's repeat. If you say you've paid all the rent, that's 7,580.
I paid all
There's-
past due fees.
All right, well, then that's great. Then if it is, if it's all paid, they can dismiss it.
That's correct, Your Honor. That we'll confirm and might need to wait a couple days just to make sure all the funds clear, and then assuming
If
that
it's not all paid, we'll address it further 2 weeks from today, December 1st. All right, do you have any questions?
I do not.
All right, well, hopefully it's all good and I won't see you again. If not, we'll address it further on December 1st at 2 p.m.
Okay, thank you.
Thank you. This is Stonehouse versus Layton, 252210. Rent is $905 per month. Mr. Fleeman, what's the current arrearage?
I'm looking at a ledger balance, $3,084, and that includes November. Court costs are $194.20, so the total is $3,278.20.
Miss Layton, you agree with that?
I know that like I'm 3 months behind, so that sounds about right. With November just starting recently, yeah, 3 months.
All right, do you have a plan?
Yeah, so actually, what had happened was I lost my job and then my car started having problems, but I have 2 jobs lined up to start. One for sure at Summit in Vicksburg. I start that next Monday. I have to go this week to do the drug test and everything. But I already got my paper, my offer letter and everything like that. And then I'm also waiting on the nursing home for LaGrange to come back with my background check for St. Joseph County. So every other one has come back for Indiana and everything. And then they'll have a start date for me there. Other than that, I just got my car fixed up so I can start door dashing now. I just had to put new tires and get like my oil was leaking onto my spark plugs and stuff, so I had to get that fixed. And my brother just recently did everything to it, so I can start door dashing to put money onto my account. Other than that, like I still don't get like child support or anything. I just get my food stamps. So
Have you asked for any emergency assistance?
no, so I just got a new copy of all of that today, and I got a hold of the legal aid and everything, and then I was gonna go into Keystone today, right there in Centerville. So I just haven't had the time yet. I wanted to do my court date first, and then I've been busy with the kids, lunch
All
and
right,
everything
well,
like
I'm
that.
gonna
So
adjourn this for 2 weeks. But
okay,
we're gonna adjourn this to December 1st.
And Judge,
I have,
go ahead. I was going to ask if it's possible for me to
go ahead, Mr. Fleeman.
I'd like to get contact information for Miss Layton. We'll get back here.
All right, Miss Gilbert and Miss Layton, you stick around. Miss Layton, don't go away. Mr. Fleeman will contact you and see if they can work out some sort of an agreement whereby he could file something called a conditional order of dismissal. I encourage you to go to those funding agencies, but don't leave yet, Miss Layton, because I'm going to put you in a room with Mr. Fleeman and he can get all of your contact information. But I don't want to put it out over the live stream. So stay with me for a minute.
Okay.
All right, December 1st at 2:05 p.m. There aren't enough hours in the day to do everything we got to do. All right, Miss Gilbert, we've been through this recently. You're not too long ago. You're Guess What versus Cassandra Gilbert. Rent here is $975 per month. Mr. Fleeman, what's the current status?
Your Honor, it looks like $3,500 in rent There is a $350 unauthorized pet fee on the ledger and court cost of $198.40, which gets you to a total of $4,048.40.
Through November?
Yes, sir.
Ms. Gilbert, what's your position?
Well, I was in, and I contacted Paul. Well, actually, the hospital did. I was in a hospital battling a bunch of stuff. Well, while I was in there, they sent my review for Social Security and I didn't get it in time. So I had to go up to Social Security. I just recently got my Social Security back.
But wouldn't they have given you your retroactive Social Security though?
No, they didn't. They cut me off completely because I didn't get it in on the date they told me to. I literally had to go up there. Like they wouldn't even do anything over the phone because I tried.
Well, I'm gonna do the same thing, Ms. Gilbert. I'm
But
gonna
I just
continue this.
also started a part-time job. So I'm working a part-time job, just started today, actually. But I did, Neighborhood Inc. is supposed to, our neighborhood, is supposed to pay my back.
Did they say how much they're gonna pay?
They said they was gonna get me caught up. That's all they said. And I just sent in, cause I had to send in my, proof of income and I just sent it in to her, yesterday.
For both of you, Ms. Layton and Ms. Gilbert, the only thing that cures this in paying the entire amount, paying a partial payment of the rent will not foreclose the eviction. So they can agree to work with you, get it caught up on the rent, but let's say that Neighborhood Inc. gives you $3,000, Ms. Gilbert. There's still $4,048.40. So you'd owe an additional $1,048. The only thing that'll cure it is paying the entire amount. But that would be
And I
great
was
if
gonna catch
Neighborhood
up on the
Inc.
rest
came and
because
paid
I'm waiting on a
everything.
back
It would be
payment
very
from Social
good.
Security. Should be here this week.
All right, and as Mr. Fleeman said, I thought they would pay your back Social Security. You may be getting a lump sum Social Security check.
Yeah.
Which may help your circumstance.
I should be here this week because I contacted them on Friday to ask where it was. They told me 5 days, so it should be here this week.
All right, now stay in contact with your landlord. If you get a lump sum Social Security check and you get helped by Neighborhoods Inc., then maybe you can pay the rent and you won't even need to be here. But I'm gonna put each of you and Mr. Fleeman in a breakout room so I can get your contact information to discuss this with you further. So
Okay.
give me a moment. Cassandra Gilbert. Mr. Fleeman, is that your last case today?
That's all I have, just these two, Your Honor.
All right, you can get the information from these ladies, perhaps do a conditional order. Otherwise, I'll see everybody here on December 1st at 2 o'clock.
Very good.
Okay.
Chrissy, you're
Or
good to go. Thank
thereafter.
you.
Hit the button that says join.
Okay.
All right, let's bring in Miss Brown and Miss Brumfield. Good afternoon, Mr. Smith.
Good afternoon, Your Honor.
Excuse me, sorry. Our next matter is KGS 517 LLC versus the estate of Kim Garcia, 920 East Hoffman Street in Three Rivers. Attorney Stephen Smith is here. on behalf of the plaintiffs in this matter. The defendants are not here. Mr. Garcia is deceased. They did substitute service on his son, Paul Garcia. This matter is set for 1:35. It's now 1:38. Mr. Smith, what do you know about this matter?
Well, I know like you say, Paul Garcia was served at the property, accepted on behalf of the estate. This is really an action for two things under statute 600.3238. It's seeking a judgment of possession as well as the immediate extinguishing of the redemption period that's running from the sheriff's sale back in August. And
the extinguishing the redemption period is because of the refusal to allow inspection of the premises?
That's correct. Notice given of the intent to inspect both, I believe both, well, it's definitely mailed. Notice of sheriff's sale purchase was mailed to the residents along with notice of inspection dated August 28th, seeking to inspect on September 3rd at 10 a.m. And my client's representative appeared. No one answered the door. No one could be found on the property to let them in. So seeking judgment and extinguishing of the redemption period. And I do see where Mr. Garcia was served personally at the residence on the 6th of October.
That would be the son, Paul Garcia.
Correct. And signed an acknowledgement that day.
This house, I think, is in distress. I've had a number of people tell me they lived at 920 Hoffman in Three Rivers.
I wouldn't be surprised. Board is hesitant at all, I'm certainly happy to have it scheduled for a second hearing and see if anybody.
I think that's what we're going to have to do. We have substituted service. I don't know that Paul Garcia is the personal representative for that estate.
Okay.
He just happened to be there.
Mm-hmm.
The house, I'm familiar with the house once I looked at it. I do believe there are people in it.
Okay.
Now, the question will also be 180 days hasn't run since the sheriff's sale in August, September, October, November. They're also asking to speed up the or foreclose the redemption period.
Right. So in a couple of weeks, you'd be shortening it from 6 months to 3 effectively by the end of this month.
Yes.
So
I'm not unwilling to do it, but I'm not willing to do it by default.
Understood.
So let's take a look. I just gave my clerk permission to put 5 small claims cases in there. Let's go to 240 on December 1st.
Anything earlier or later on that day? I've got a mediation.
How about 1 o'clock?
1 o'clock would be great on December 1st.
What I expect is that no one's going to show up, and I'm going to grant both of your requests by default, and then have 10 days to vacate.
Sure. Plan on it.
All right, I'll see you in 2 weeks and let's see how we're doing then.
Okay, very good. Thank you much.
Thank you. All right, we're about to switch gears to our general civil docket, which is always jarring. Mr. Cox, are you here on Three Rivers Hospital again?
I am.
Heather Hooley?
Right.
All right, well, we're a couple minutes, it's now 1:45. Ms. Brumfield and Mr. Brown, can you hear me? I had somebody in the Zoom room. Elaine, have I got, or Michelle, have I got somebody in the hearing room? I saw the Zoom room come open, but I don't have it open now.
Sometimes it does, they have.
All right, that's Miss Brumfield and Mr. Brown.
Yeah.
All right, good afternoon.
Good afternoon.
All right.
Good afternoon, Your Honor.
Mr. Cox is here on TR Health versus Hooley, and Ms. Hooley is not. Mr. Rusin is here on LVNV funding versus Tracy Johnson, and she's not present. And Mr. Shivelbein is here, Heartland versus Deerduff, and Deerduff's not here.
I'm sorry, Your Honor, did you say?
So,
Oh, sorry.
I'm sorry, no, you're here on H. Zinnack versus Brumfield and Brown, is that correct?
Yes, sorry, I just wanted to clarify.
All right. Okay, I can't see you, but, all right, let's take Mr. Rusin first. He's out there under the bridge and we want to get him on his way. Good afternoon, Mr. Rusin.
Hi, Judge, how are you?
Let me just check to make sure she's not here. I'm looking for Tracy Johnson. Yeah, we got them in the Zoom room. That's Dorinda Brumfield and Angelo Brown, but all right, thanks. All right, bye. All right. This is entitled LVNV Funding versus Tracy Johnson. The file number is 25856GC. The esteemed Richard Rusin is here on behalf of LVNV Funding, and Tracy Johnson is not. This is a summary disposition matter where the plaintiff contends that the defendant has not stated a defense and there is no material issue of fact. They did provide a motion and an order for summary disposition. Problem is the order, maybe I'm missing a page. It doesn't show what the amount is.
I can be helpful on that, Judge.
All right.
If I may, for the record, Richard Rusin by Meyer number 35222. The amount that I'm seeking by means of summary judgment is based on the complaint. The complaint was filed in the amount of $1,499.59. Your Honor, I can also tell you that up to the present moment, there have been taxable costs in the sum of $55 summons filing fee, $69.31 summons service fee, and there have been $40 in motion fees that have been paid by the plaintiff since summons issued herein. The total costs are $164.31. Judge, if you grant my motion for summary judgment today, I would ask for a $20 statutory attorney fee for a total judgment of $1,683.90. And if you do grant my judgment, I'm prepared to e-file the proposed judgment order before the close of business today. With that, I rest.
All right, I'm going to sign the order. Granting summary disposition, both on the merits and the fact that she's not here to argue about it. I'll indicate plaintiff will provide judgment. All right, Mr. Rusin.
Thank you, Judge. I rest. And that's the only thing on your docket today. And have a great day.
All right, thank you.
Bye-bye.
All right. Let's address here was Health versus Heather Hooley. I'm disappointed that she isn't here because this hearing was set up for her. File number is 23299GC. It was original claim for $5,808 plus cost. Mr. Keith Cox is here on behalf of the plaintiff for the second time today. The defendant filed a motion for installment payments. And I set it for a hearing because we often end up chasing our tails. The debt is substantial. It's bigger than it was. It's now $5,999 or thereabouts. Defendant indicated that she's being laid off from IAC in Mendon. And that's one of our longtime employers, and they are closing their doors. So she asked for an installment payment of $20 a month, which is not very much on a $6,000 debt. It doesn't even cover the interest. I do understand that she's about to lose her job. I think they're closing their doors very soon. Mr. Cox, you have any input?
Well, Judge, I was reviewing the file. It looks like there is a valid installment payment order on file with the court that was entered back in June. She had moved the court at that time for $50 a month payments, which this court granted, and those are still in effect. The most recent payment that we received from her was on October 29th, not that long ago. She paid $100. And then I think she was trying to catch up. She had fallen behind a little bit already. She paid us $50 on September 4th. So to amend that order and drop it down to $20. The balance is only now $3,320.88. We do show that she has made payments over time, over $3,000 worth of payments. So she has made progress on this, but yeah, we were not agreeable to the amount of the proposed amendment. And so we're asking at this time the court just leave the $50 a month installment payment order in effect. I don't know what the defendant's position is with regards to that today. But we do show a payment as recently as about 2 weeks ago.
Existing installment payment remains in effect. $50 per month. First of the month. Defendant failed to appear for the hearing. She requested. So we'll stay at $50 a month. There are other jobs to be found. They're not just IAC. Been a good company for a long time. And it's too bad that they are closing their doors. But she's been making her payments. She isn't here to argue her cause. And we'll leave the current order in effect.
Very good.
All right, thank you. I'll see you next time.
Thanks, Judge. Have a good day.
All right, next is we'll put this file back together. Entitled H.Z. Zinnack versus Dorinda Brumfield and Angelo Brown. Dorinda Brumfield and Angelo Brown are in the conference room here at the courthouse. Good afternoon.
Good afternoon, sir.
I've got you in there not because I'm unwilling to have you in here with me, but if I need to put you in a private space where you can talk to their attorney, I can do that. Mr. Shivelbein, would you join me, please?
I am here, sir. Your Honor, I apologize. My camera is not working on this computer. I can try to call back in by phone if that's okay, but the video quality will be lacking. But otherwise, I am here by call. Is that acceptable?
Well, we'll do the best we can. Thank you for being here. The file number, if I didn't call it, is 251366 GC. The defendants were subject to default in this matter. The default entered September 10th in the amount of $8,250.02. $149.04 for a total of $8,399.06. This had to do with an automobile loan on an aftermarket high interest loan on a car. the defendants were served with a lawsuit and didn't answer it. So the default judgment entered. The summons prayed for damages in the amount of $7,258 plus interest and costs. So judgment entered in that amount. Judgment entered, and the defendants got a copy of the judgment, and then they wrote a letter expressing all their dissatisfaction with the vehicle. We received the letter on October 22nd, which in point of fact is more than 21 days past the entry of the default. Any motion to set aside a default is supposed to be filed within 21 days of the entry of the default. This was filed 32 days after the default entered. I'll just read it. We are writing in reference to this case to inform the court of our financial situation and explain our position. We are currently living on a fixed income and do not have the financial means to cover the vehicle repairs or unexpected expenses. The car we received from JD Beinreiter experienced transmission failure twice. We requested a trade for a working vehicle, but our request was denied. Due to the repeated mechanical issues and the refusal to revise replacement, we informed JD Beinreiter to retrieve the vehicle so we could pursue a reliable alternative. We do not accept financial responsibility for a car that was defective and failed to meet basic standards of reliability. We respectfully ask the court to consider these circumstances in reviewing our case. We've acted in good faith and done to the best to manage our obligations within the limits of our income. You bought this car. They're sold without a warranty. I get 20 of these a year. Somebody buys a car, the car fails, they stop making the payment, the car is repossessed, the company sells the car for less than what the people paid for it. And this was a 2011 Nissan Rogue. You paid 19% interest. Ooh. The car was $7,100. No. The car was about $7,000. You paid $7,000 in financing charges, and all of a sudden the car is now $23,000. There's a couple problems with this. One, this was sold without a warranty. And two, you didn't file an answer. And three, you filed your motion for default more than 21 days after the entry of the default. Mr. Shivelbein, what's your position?
I do want to clarify for Miss Brumfield and Mr. Brown, there was an optional service contract within their retail installment contract.
Okay.
However, I'm going to note this vehicle was sold at 108,000 miles when it was sold to them, and it sold at auction at 171,000 miles, which was almost double that service contract. I understand that there is frustration with needing repairs on these used vehicles, but I did want to clarify that there was a service contract, but it was well beyond that service contract. I felt that did need to be clarified.
Now, how long was the service contract for?
36,000 miles.
Okay. Thank you. I wasn't aware of that.
I am happy to discuss, and my client did also reduce down to the 13% statutory interest rate, I believe, in the judgment. The statutory 13% rate. I'm more than happy to try to discuss an amicable payment arrangement if Miss Brumfield and Mr. Brown want to reach out to my office. I can try to see
Well,
if
I
my
can
client
put you
will
in a
waive
breakout
interest.
room with them right now.
Excuse me,
Yes,
I want to say something.
I can't hear you very clearly, so speak up.
That's nothing. I had 4 strokes between July and August, so if you can't hear me, I'm trying to talk as loud as I can. But if the gentleman tell you
No,
that,
Mr. Brown, I can't understand you. Why don't you come right into the courtroom? Leave that room open and you come in here. Good afternoon, Mr. Davidson.
Good afternoon, Your Honor. Happy Monday.
Good afternoon. Why don't you guys just sit right here at this table? All right, this is Mr. Brown and Miss Brumfield. I know them. I've known them for many, many years. And did you hear everything I said when you were in the conference room?
yes,
Yes, he was trying to let you know that he had a stroke and he's trying to
had 4
talk.
strokes.
Oh, I hadn't heard that.
2 in August, but so that's why you can't hear me. But gentleman will tell you, we kind of tell you, the last payment we made on that car, what month that was. Because that makes a big difference. Because I told her, I said, when we called them the first time, and they did the judgment, the second time we called them, I said, honey, there was some run around, and because our warranty is about to run out. So they had us come take the car to JB Byrider. We had someone follow us, because the car would barely make it. So we went through the back roads, all the way to Kalamazoo. And my nephew followed us so he could go back home, but they kept the car. Now, when they kept the car, they came back in 3 days to get the car. We had someone phone pick us up.
Well, let me stop you. All this is maybe irrelevant. You got sued. You didn't answer the lawsuit. So you got defaulted. You have 21, leave that room open, please, Elaine.
Oh, okay. You don't want to.
I'm gonna need it. I may need to put them back in there.
Okay, will do.
You have 21 days to move to set the default aside. You didn't do that. 32 days later, you moved to set the default aside. Also, you're raising these defenses. The car had 76,000 miles on it and your warranty was only for 36,000 miles.
Exactly. So what I'm trying to say, Your Honor, you please just allow me. When we took the car up there, we still were under the warranty. When we took the car up there, then they sent us back home. When we got the car back, the car was still messed up. So we still paid 3 months after we got the car back, kept trying to get them to fix it. So what they did, they stopped answering our calls. I said, honey, our warranties went out, so they're predators, they're not letting us pay, and they don't want to call and fix the car or nothing. So 3 months passed, I think we paid this car note. They were not fixing anything. So then they said, well, we gotta come get the car. Okay, if you come get the car, it's fine, because we tried to call you 3 months. They want to answer the phone. Now, what happened with the company, JB Ryder, they got rid of the people who were handling the payments in the office because they would not answer our phone call. When they had a new person in, she called us and apologized. We apologized for the mishap. That was not a mishap. That was on purpose, because they knew that we didn't have the warranty on that car, and we were paying the money, not getting the car fixed. So she had doctor's appointment. I have doctor's appointment. We had no way to get around.
Well, you put 25,000 more miles on it after the warranty expired. It had 171,000 miles on it when they repossessed it, 108,000 miles when you bought it. You put 63,000 miles on it. So if it was still under warranty and there were issues with it, you drove it another 25,000 miles after that.
When we took it to them, they, like I said, they put the 2 transmissions in there. When we took the next time, They would not fix that car, and answer our phone calls or anything for 3 whole months without answering the call or nothing. Then they call and say, oh, we sorry for that incident. We got rid of those people, so now can you guys pay us? Now mind you, 3 months we paying this car note without a car, having to go to the hospital, doctor appointments, so forth, unable to get there. They didn't care. They did not care, they didn't help us at all. Now they want to take the court and say, we want $8,000. That is ridiculous. That's ridiculous. That was a predatory loan they did on us.
Well, I don't know whether it wasn't. It's got a 19% interest rate. Loan sharks used to charge 6. These are very high interest rates, but nobody puts a gun to the people's head and say, hey, you got to buy this car. Only one of us can talk at a time. So you signed this contract. Nobody made you do it. You bought a $7,000 car. I don't remember, a $14,000 car with $7,000 worth of interest payments. Then it already had 108,000 miles on it when you bought it. You put 63,000 more miles on it and they repossessed it and sold it. Then you got sued. You had 21 days to file an answer to tell me everything you're telling me right now. Tell me what your defense was. You didn't answer it. So then they defaulted you and they entered a judgment against you. You have 21 days to move to set that default judgment aside. You didn't. 32 days later, you come in and say, well, wait a minute. I had all these defenses I could have told you about. I'm not sure they're even valid defenses, but at least it's your side of the story. So they're not gonna agree to this. What they may agree to is some sort of repayment. But right now you owe this money. You got sued, you didn't file an answer, you got defaulted.
I know it was paying.
All right, and so that may be what's called judgment proof. Now the original car loan was at 19.5% or something. Now it's at statutory interest rates of 13%, which is still bad enough. Mr. Shivelbein was agreeable to speaking to you two privately. And I'm going to put you back in that room. Now, Mr. Brown, I've known you for 40 years. Yes. I didn't realize you had a stroke. That's horrible. And so it's hard to understand you. You're in there and I can hear it. But Mr. Shivelbein, this is filed as a motion to set aside a default. What's your position regarding that?
My client would object to the motion. My client would be willing to have a discussion, but at this time they're in opposition to that motion.
Can I ask a question?
Yes, sir. Yes.
Okay, if they took the vehicle and then resold it, then should we be out of that contract?
Oh, no.
Really?
They sell it for way less. It's a bad deal all the way around. All right, so they sell it at auction for, I don't know. I'll just pull some numbers out of the air. Let's say $10,000 is owed on it. They sell it at auction and it's sold at an open and fair auction, and maybe somebody pays $3,000 for it. So they offset what you owe by the $3,000. People always want to say, hey, this car doesn't work. It's no good. I give it back. I'm good. That's not how it works. You can't just give it back and be out from under the contract. So if they sold it for what you owed, then they would cover it, but they sold it for much less than what was due on it.
Yes. And there was no way we could do that. We could, when we got the car back, that car would go over 45 miles an hour with that transmission. That means we had to, for 3 months.
Well, you drove it for 25,000 more miles after the warranty was expired. Would you take them back in the conference room? I'm gonna let you speak privately with Mr. Shivelbein. I'll still be here. I got other cases stacking up. These civil matters at 1:15 are always a thorn in my side.
All right, thank you, Your Honor.
All right, we may not be done, but I want you to have a chance to talk with him privately.
Yes, sir.
We just don't understand.
Michelle, can you hit the join button for the Zoom room,
Yes, sir.
the breakout room? All right, I don't think we're done there, but we're going to return to our landlord tenant matters. As I said, that's always tough when we have to switch gears from landlord tenant to general civil motions where the people don't really understand the court rules very well. All right, we've got Heartland versus Deerduff and Heartland versus Deerduff. Mr. Davidson is here on those matters. Mr. Dutka is here on Elena Gales and Raina Moyer. Is that you?
Yes.
All right, Elena Gales and Raina Moyer are here with me in the courtroom. Mr. Bush is here on Hartman versus Winicky. And that is now I've got Samsung. Is that you, Holly? Could you unmute your mic? All right, so that's Holly Chittister. And then I've got Zoom user, which is John's client. And that is Judy Hartman. Oops. I did it wrong. Sometimes the things jump around. Samsung is Holly Chittister. All right, Mr. Davidson, let's take up your matters. There are two of them. 252097 LT is apartment A at 210 West Bennett Street. 252139 is apartment B at 210 West Bennett. We didn't have personal service. Is a little odd. Mr. Deerduff quit claimed these properties to Heartland Rental, who was there with Mr. Davidson. There were tenants in there. The place was really not good. Mr. Deerduff had people in and out of there. We weren't able to do a default last time because it didn't have personal service. These are filed as termination of tenancy. No one is here for any of the defendants. Mr. Davidson, are you going to simply ask for a default at this time?
Yes, please, Your Honor. Angie Price showed up later. Basically, there were no leases. Deerduff was whatever arrangement he had with these people, we don't know, but he had no leases.
Yes, they were very tenuous. He had a number of termination cases of his own, and it was not good.
But thanks, Your Honor. Yes, please.
I don't think I have a judgment. Plaintiff may have, I should have, but I don't see him. Plaintiff may have possession. There are still people in there, is that correct?
Yes, Angie Price showed up at the last hearing. She came late. She wasn't there for the
Yes.
hearing, but she came late. I don't see her today. We didn't hear from the other fella. Bruce Moore's had a name on the proof of service. I think that was a person in the other lower apartment, and Angie wouldn't answer the door for him. That's why he posted it after 3 times. But she did show up.
Vagrants coming and going.
Or you can have a default judgment on each unit 10 days from today is November 27th, which is the day before Thanksgiving. So the effective date will be December 1st.
My paperwork indicates that there were proposed judgments in each file.
Well, let me look. I thought there was one. Let me see if I separated it. Yep, here's one. I find by default, plaintiff has a right to recover the property on or after December 1. Same in each case.
Thanks, Your Honor.
No money judgment entered.
So Bob, so what happens if we have a judgment today? What does that mean?
It's gonna be, they've got 90 days.
90 days to move on.
To move on.
Mr. Dutka, your mic's on.
Thanks, Your Honor, sorry.
All right, I've granted the default in each case. I'm sorry you even have to wait 10 more days, but there are tenants at sufferance in there.
There we go.
I can't find the second judgment, but if I can't find it, I'll have her make one.
Well,
All
I
right,
can send
same
it
as
over.
each case.
No problem. I can send it over. We've got it done.
Yeah, why don't you go ahead?
So which case did you do it in? Which file?
I did 2139.
Okay. I'll do the other one. I'll do 97.
All right, thank you, Mr. Davidson.
Oh, thank you, Your Honor. Sorry about that.
I think I probably had it. I don't know, may have misplaced it, but you've got one on your computer. Just send it in and I'll sign it.
Yep. Good to see Bob and John.
As for you, sir, you gotta wait 10 days. They can get everybody out of there. There's a great demand for rental properties in Three Rivers and everywhere for that matter. If you get them out of there, I'm sure you can find some good renters. All right. Next up is let's see what our time is here. All right, Mr. Davidson, you're good to go. Heartland 220 is Mr. Dutka. Robert Kolasinski and Carolyn Kolasinski versus Elena Gales and Raina Moyer. Would you come have a seat right up here? Mr. Brown and Ms. Brumfield, will you come back up, please? Mr. Shivelbein?
Yes, Your Honor.
Your client objects to the setting aside the default judgment, and the defendant did not file their objection in a timely manner. You had an opportunity to discuss the matter with the defendants. Did you make any progress?
I offered my phone number. It doesn't appear that there could be a discussion at this time. But I've received a phone number, so I'll try to reach out at a later date, later this week, and maybe a discussion can be had. But as of this time, there is not.
All right. I'm going to have the court officer take you out to the office. Your motion to set aside the default was denied. You didn't file an answer within a timely manner. You didn't move to set aside the default within a timely manner. And even if you had, I'm not sure that you set forth a meritorious defense. So you're stuck with this debt. Now, if you can't pay it, you can't pay it. They can't weave gold out of straw, but the debt isn't going to go away either. So he's got your contact information. You have his. I'm going to have the court officer take you out to the counter and get a copy of this order. Mr. Shivelbein, you guys can discuss this further, but the motion to set aside the default is denied. All right. Thank you.
God bless you.
All right. Good luck to you.
Have a good day.
I
Your
know
Honor.
it's difficult. All right. We're back to landlord tenant. This is Robert Kolasinski and Caroline Kolasinski versus Elena Gales and Raina Moyer. So let me make my notes. We were here on November 10th. Same parties were here. This was a land contract issue for a property on M60 in Leonidas. No payments have been made for October or November. And Mr. Dutka, what's the current status?
Agreed, Your Honor. No difference in 1 week. The total that they owe of principal and interest payments is $3,300. I did determine through the county treasurer that the 2024 property taxes have been paid. I never did, unfortunately, get a return call from the Leonidas Township treasurer, so I have no way of knowing if the 2025 summer taxes were paid or not. So we'll go with what's still owing on the contract for principal and interest.
All right. Ladies, you'll have 90 days to redeem this, meaning either get conventional financing and purchase the land contract or get caught up and be ready to go from there. What's your position?
I'd like to keep my home. I'd like to get it caught up.
What is the monthly payment?
600.
All right. And Mr. Dutka, this is, did we determine it's less than 50% of the purchase price?
That's correct, Your Honor.
Fine by hearing. The land contract has been forfeited. The current amount due is $3,300 through November. Court costs are $55.40 times 2. Plus $75 statutory, $240.80 are court costs. Do you have a number for the taxes?
No, Your Honor, I don't. That will have to go with just the principal.
I'll put in play that here the following breach pay taxes. So that's $3,540.80 within 90 days. 2024 2025 taxes. You have 10 days to appeal this, which would be, I'll go with December 1. Now, that gives you 90 days or possibly even more, but no less than 90 days to try to redeem this. To either work something out with the seller or get your payments made and up to speed. Of course, in December, another payment is going to be due. In January, another one.
Right.
But you've got 6 months to try to get this in a position where you can keep your home. All right, do you have any questions?
Yeah, Your Honor, today I'm disabled. I was at home and somebody pulled into our driveway and I recognized the vehicle and the trailer and took a garage full of stuff out of the property. Scrap metal and a couple couches and stuff like that.
Out of the garage?
Out of the garage.
Now, who is that?
It was a guy named Randy that works for Bob. And I just, Kolasinski. And I was wondering, is that something that can be done?
Just a minute. Mr. Kolasinski, did you send anybody out to the house to remove property from it?
Your Honor, he's not online. I have Mrs. Kolasinski with me. I do believe.
Did anybody go out there and take
I was made aware of that just before the hearing. Yeah.
That's what I have.
Well, they can't do that. I don't know if that'll become an issue later, but you can't just go out there and go in there when you feel like it. They have a tenancy. And so, all right, thank you for alerting me to that.
I got pictures. I mean,
all right, well, we'll see where that goes, but I'm gonna have the clerk bailiff take you out to get a copy of this.
Because I want to work something out with my land.
All right, you stay in contact with him. You contact directly or through Mr. Dutka's office.
Now, when I make payments, who do I make payments to?
You make them the way you always used to make them.
Okay, I used to deposit them in his checking account.
That's the way to do it.
All right, thank you.
Thank you, Your Honor.
All right, Mr. Dutka, thank you for your help.
Yeah, no problem.
Mr. Bush and Ms. Chittister and Ms. Hamilton, I'm gonna skip ahead for a minute, but I'm warning everybody, this next defendant has some serious mental health issues. And she was very she's mentally ill. She had gone to the forensic center for a competency evaluation and spent some time there, and she was restored to competency. I'm not sure she's competent now, but she was quite delusional last time, and I had to mute her microphone. Who do you need?
Oh, their judgment. Do you have that?
Whose?
Oh,
I sent out Michelle.
Thank you, Judge.
All right, so stick with me. I'm also going to bring in Meg's backup. Miss Conway, can you hear me?
It is.
Elizabeth, can you hear me?
Yeah, I can.
All right, this is Judge Middleton. Your landlord, Susan Churchill, is here with me now. The file number here is 252111LT. As I told you when we were here last, your landlord wants you to move out. And she's asking for me to order that. Last week, you were very animated and upset, but she still wants you to move. What's your position?
I don't mind moving. All I need is a ride to go back home to Constantine, and they didn't. I know that I don't know why. I don't know if maybe they'll give me a ride or not. I don't know because her roommate is trying to get me to not prosecute him because I already have charges on him right now. I just talked to the cop the other day about So I'm trying to be like really nice about it, and even though it makes me breathe weird. So I really didn't want to even go back there, but I had to go back there because my car was stolen and stuff like that. So, and my mom passed away, and all of her family is like going through a lot right now with that. So it's just been, we had a lot to get done. So, yeah, I know he's trying to get me not to, I mean, I'm the only one that can dismiss the charges, but I mean, because it's Sturgis Police, or no, Three Rivers PD, right before my mom passed away, took me 100 miles an hour to Kalamazoo to do one of those kits. I don't know if you know what I'm talking about. I don't want to say it out loud, but one of those kits for unwanted contact. So I didn't really want to have to do that though, because all I wanted was for him, because my mom and Sarah Bingaman, my father's ex-wife, came to pick me up. All I wanted is my clothes. They're brand new. I didn't care. I've been through it before. I don't need to.
All right, Elizabeth, you've got 10 days to get all your stuff out of there.
All right.
Or she can have the sheriff put your stuff out. Now, you actually get a little more because 10 days would be Thanksgiving. You get till December 1st.
That's fine.
Where do I send your mail?
I could probably get a cop to take me home.
All right. You have 10 days to get your stuff out of there. No money judgment is entered. This is just a possession judgment. Do you know where you're going to go?
I'm going to go back to Constantine. I don't have anything illegal to that. So go back there. It's my property.
All right. Well, you need to get out of there and get all your stuff out of there
I have
within
a
10 days.
I have a question for you for a second. Is it all right if I ask or no?
Go ahead.
Remember that misdemeanor I pled to? I found out that guy wasn't even an officer. What do I do about
There were
that?
several driving
No, I'm talking about the
misdemeanors.
misdemeanor from the hospital. That wasn't even a real officer, I found out.
Well, there were some disorderly persons. There were some retail frauds.
Yeah, disorderly was
there was-
illegal. Ron Fuller threatened me not to prosecute, and I'm the Bingaman's family members all out in the last few years. Because my mom's Teresa Bingaman, and she just got her married last name, so Winrick. But yeah.
Elizabeth, are you seeing anybody from Pivotal?
No, I don't go to Pivotal. I haven't gone to any CMH or Pivotal, period.
Well, you need some. You're not doing very well.
Well, no, you guys
got 10
attempted to
days.
murder these people attempted to murder my mother and multiple people in this county, and I witnessed it. So I'm not doing very well. It's not normal. It's normal for me to feel like this.
All right. Well, you got 10 days to get out of there. You understand?
Yeah, I don't need that many days. So
all right.
I don't feel
Miss
comfortable with
Churchill,
that.
you have to allow her access to get her property out of there.
Oh, I'm getting a
But,
check
Miss
from my mom. So I have to get that out of the mail when it comes.
All right. Miss
I like to
Churchill,
make
you
that
go out to the office, you can get a copy of this. Miss Conway, let me repeat, you have until December 1st to get all your stuff out of there.
Okay.
All right. Good luck to you.
Bye.
All right. That went better than I had hoped, but hopefully she'll get her stuff out of there and you can have your property back. Go out to the counter and the clerk will give you a copy of that order.
Okay, thank you.
I'll just put that in the waiting room. Put the waiting room in the waiting room. All right, this next matter is a little involved. It is entitled Mike and Judy Hartman versus the estate of Natalia Winicky. Mr. John Bush is here on behalf of the plaintiff, and Natalia Winicky is also present, or she was. I lost her.
It's her daughter.
Yes, I understand. Natalia is deceased. Holly Chittister, her daughter, was here with us, and I've lost her. This was a strange land contract that did give the, here she's back, the person the property to us, the permission to assign it. And more than 50% of the purchase price had not been paid. Mr. Bush, what's the status here?
There's no change, Your Honor. And I don't really know how much difference it makes if it's been assigned or not been assigned. No payments have been made. and their urge now is $6,750 plus costs.
Give me that number again.
$6,750 through the month of November.
What are the costs here?
I had a filing fee of $55, Southwest Legal of $26, and I believe we get the statutory attorney fee then.
Yes. 157, 156. $6,906.
My position, if it's been assigned or not, and we haven't received any notice that's been assigned, the assignee would still be stuck with their urge and would be under the, I think this judgment would be binding on the estate or an assignee.
Ms. Chittister, what's your position?
I spoke with my niece and she is planning to get this caught up. That was one of the things I needed to find out was the probate was continued, and I am seeking an attorney's assistance on this regarding a few things, but my niece is planning to catch up the amount that was owed. Part of it, like I said last week, was the fact that she was diagnosed with cancer and was going through some treatment, and the hospital was going to assist her with that payment. But we could not ever receive anything from the Hartmans or Mr. Bush to confirm that she was living there and the payment amount to allow them to issue those benefits.
Well, I don't know if they knew it, but
I had sent a letter to them, and the social worker from the hospital had also requested the same information. And she had sent the letter as well to Mr. Bush's office and then to the Hartman's address that we had for them.
so
And
they intend
unfortunately,
to
we
catch
did
the
not get a-
contract up?
They were going to make the ongoing payment during the treatment, the cancer treatment and recovery. And because they couldn't confirm that that was the agreement, they were aware of the probate, and they were trying to make that payment for Nicole, but we could not get a response from either the property owner or the attorney. So the hospital had to put that on hold, and they could not make that ongoing payment during that time. Otherwise, we wouldn't even be here.
Do you have any response to that, Mr. Bush?
We would have no idea who's occupying the premises.
I thought I had a judgment here.
I thought we sent one over. If not, we.
I don't have one. Which may be a reflection on me rather than you. Let me see.
We very well could have missed it, Your Honor. We typically send
Let
a
me look in
judgment
the
over.
electronic file and see if there's one in there, and I'm just not finding it. Ms. Chittister.
Yes.
You're not in the property. You are the personal representative for your mother's estate, and it's your niece that's actually in there, which would be Natalia's granddaughter.
Yes, correct.
All right. And somehow this is their fault because they didn't give you the information regarding who was in there. But I asked the same question. How do they know who's in there? And go ahead.
I'm not saying it's anyone's fault. I'm just, they had previously had a judgment that my niece Nicole had paid that was in her name. And she has been the one that was making the payments. She had moved in with my mom prior to my mom passing away because my mom needed someone there to care for her. She had transferred the land contract to her in writing, which is what the probate is about. And Nicole continued to make the payments for a number of years since my mom had passed away in 21. So, and she was named, and if they had had questions, I had indicated that they could reach out about that, as well as the hospital had indicated that. It would have avoided this whole problem because they could have, the hospital was willing to make that payment for Nicole while she was in treatment.
That's quite a benefit, but during her treatment. So that's certainly a blessing. But anyway, John, I don't have a judgment in here.
We will get one over to you this afternoon, Your Honor.
All right. You have through November, $6,750, $156 in costs. So the amount in arrears is $6,906. Taxes may also be in arrears. I can't tell. Are the taxes in arrears?
This is an escrow payment, Your Honor.
Okay. All right, then that's the amount.
That is the accurate amount.
$6,906 due within 90 days.
In Your Honor, can I say something?
Yeah. Yes.
I've never been given Mrs. Chittister's phone number that I could ever reach her. And I've asked several times when we've went to court, but I never get one. And I didn't respond when they asked for whatever this was supposed to be, because to my knowledge, they've never done the probate or anything. So I don't even know if this woman is legally there.
All right, Ms. Chittister, as the PR for the estate, you have 90 days to redeem it. Of course, in December, another month's due, rent will be due January, February. But right now, through November, the arrearage is $6,750 and $156 in costs. I'll indicate John Bush to submit judgment.
Okay. Can that be paid at the credit union as the payment has typically been made there? Or does it need
Yes,
to be
as
paid
it
to
always
the court?
has been.
Okay.
Yes.
All right.
All right.
Thank
Thank you all. You're good to go.
Thank you.
Judge. Thank you, Judy. I'll get you a copy of the judgment, Judy.
Okay, thank you.
Thank you. I thought I had a judgment, but I looked and looked and there is not one in there. So he's going to send me one. All right. Next, we have Mr. Davidson is done. We have Wolf Senior versus Wolf Junior. And John Bush is here on that matter. That is set for 245. It's 247. Ms. Hartman, I'll release you so you can go on about your business.
Okay, thank
Ms. Spiegel, which case are you here on?
Sorry, Your Honor, I had to unmute myself. I
Thank you.
was observing the last case. Our office represents the occupant.
Okay, I'll note that. Legal aid represents Nicole.
But of course, since she's not a party, we don't have an appearance filed.
Yes.
I can certainly stay online if it would help in case anyone wants to speak to legal aid, or if your call is nearly done, I can sign off if Your Honor would prefer.
I'm done with her. I've got another matter that it doesn't look like the defendant is going to appear.
Okay. I will sign off then.
All right, thank you.
I appreciate your time.
Thank you. That's why I'm here.
Thank you.
All
Have a
right,
good day.
next matter, thank you, is Michael Wolf Sr., his estate, versus Michael Wolf Jr. The personal representative is Nancy Nelson. We were here last, November 10th, and Michael Wolf was still in the property. It belonged to his father. He had another woman, Chelsea Peavy, that was also living there at one time, indicated she's no longer there. He indicated that he planned to move. The matter was continued until today. John Bush is present for the plaintiff. Mr. Bush, you have any knowledge of whether the defendant is still there?
I believe so. The plaintiff just contacted my office. Apparently her son just doesn't understand the concept of this is an estate trying to evict him, and he hasn't been real forthright about moving. She needs to get him out.
Well,
so she
here's
can sell the
somebody by
property.
telephone. Well, as you know, we get these several times a year. The estate then wants to remove a brother or a sister or somebody who was living with mom, and they don't often understand. They don't want to go.
Pretty much
Mr. Wolf, is that you?
Yeah, I was just going to ask if this was my meeting or not. I apologize, Your Honor, but
Yeah, you're late to your own party, but let me.
Hey, it ain't a party.
Oh, well, they want you to move. What's your position?
My only thing is this, Your Honor. I really don't want to throw anybody under the bus or anything about this whole situation because it is painful. To me, and I know a lot of other people, but if they say I'm unapproachable or whatever, I've been doing work for my mom, you know, to kind of like try to help out with family stuff. And I've been doing work here. There is work, you know, been being done here. And I know that there's always bills. And I just went down to try to get a job back at Forest River, and their head guy wasn't there in the office today. I just went there Friday. They told me to come back today with my ID and my Social Security card, but he wasn't there again today. And I'm saying I'm trying to either provide a service. Sorry, I don't have my teeth in right now. Or do something that actually benefits my family. And like, it's not anything on it is my fault for staying here and not having a job sooner. I just had to get through. I finally got off the methadone clinic. I got off Suboxone, and I don't know if they understand that stuff takes time, but I regret ever being on it. And I'm just asking for some leniency, I guess. You know, my dad might have been an enabler, but it isn't like that. If I'm, I don't want to put this to where I'm not saying something bad about my
Mr. Wolf,
mom.
this happens multiple times each year. You were living in your father's house. He passed away. His estate wants to sell the house. And
that would be awesome because that would be awesome because I'm actually, I don't like this house. I don't have any good memories of this house. My brother has put a lot of things in my mom's ear that would say that he wants to buy this house, but I mean, he works at Armstrong's. He shouldn't have a problem buying this house. Now to say that they can't get any square footage of this because it's so crazy inside is, I mean, I can measure a room right here. I can give you square footage of this place off of just the measurements from wall to wall, because you can walk to every one of them. So I know it's not as bad as some of the places that I've been in my lifetime. So I don't understand what the hang up is, because if anything was ever to be said and done, I will take any money from whatever it is that was actually supposedly mine in the beginning because of him having no will, and put it right back into everyone else's pockets. It's not like I've ever been trying to take a shortcut. I just might not have went the right way sometimes. And I think that's just, well,
Mr.
I'm
Wolf,
sorry.
the
That's
cold
not it.
hard truth is you have 10 days to move out of there. If
Okay.
you are an heir of the estate and they
Do
sell
I-
it, you may get some inheritance. If there's equity in the house and you're one of the heirs, you'll get your share of the
Yeah, good.
inheritance.
I'll
But
probably
you
live with my
don't have a
dad's kid
lease.
then.
You
Yeah.
don't own the house. The estate owns the house, and the estate wants you to move. And so
And
this
so
is
that's my
the
mom,
judge
right?
telling you the bad news that you have 10 days to move,
No,
or the
you're telling
sheriff
me
will
no
come,
bad news. You're just
or the
telling me news
sheriff
that
will
doesn't
come
have.
put you out of the house.
Yeah, that'd be cute. What I'm saying is this: my mom just dropped me off clean clothes right before I had this meeting, so it's kind of on the this, that, or the other of like, are you really wanting me out of here? Are you going to give me more stuff to move? Thank you. You know, so I think there's a lot of things in play with this, but you guys just, you know, you're going to do what you do. That's great. You guys are the court system. It's amazing. And I'm going to try to adhere to it without ever having to see you again, because that's been my lifestyle. So I appreciate
Well, they
you for
sent
doing
you a
what you do.
notice to quit back in July
Yep,
16th.
my court.
They've been
Mm.
trying to get you to move since early last summer. You
You
haven't
want to know?
moved. You've lived there for all these months without making any rent payment or house payment. They want
I'm
you to
getting
get
paid by
out so
my
they can
mom.
sell the house. So you have 10 days. Now you get a few extra days because it's Thanksgiving. John, I don't have an order in this case either.
I know there's not one there, yeah, so we'll send one.
The date for the writ in this case would be December 1st.
Okay. The one thing I do want to say is I just got my court papers in the mail for this order this afternoon. So that was tough. And I'd hate to see someone else get blamed for, you know, failure to appear or something like that for getting court papers in the mail the same day they have court. That is something, because
Well,
if you don't have a
Mr. Wolf,
memory.
this didn't sneak up and bite you in the ankle. I told you on November 10th, the hearing was today at 1:45.
I know that. I know that. I listened to you. That's why I'm glad. I will say this. I'm glad that I do have a working head on my shoulders, and I acknowledge what you're saying. So
All right, very good.
don't ever take that the wrong way. But you know,
I
it's
acknowledge
just,
it's a tough circumstance, but you gotta get out of here. They
yeah, I
can
do.
sell
I
it.
do.
An
Yep.
heir, you'll
I
get
do.
some of the proceeds of the sale if there are any. I wish I had a
Yeah.
better answer.
No,
It's gonna take
I
this one to come there in the mail also, but assume
okay.
you have till Monday, December 1st to vacate. They don't
All
have
right.
to evict you December 1st.
No. Okay.
They can't.
All right. As long as I can get past the eviction, that would be a benefit, Your Honor.
All right,
So
I'll send you a
I'll do
copy
what I
of
have
that
to.
order.
All right.
All right. Good luck, sir. Anything to add, Mr. Bush?
No, this is awkward, but what you're saying is the state is right, and we believe he would be a beneficiary of some of the proceeds, so we need to get it sold.
Yeah, we
All
do.
right.
Yeah, we do.
All right, very good, Mr. Wolf. All right, these cases, awkward's a good word for it. It comes up multiple times a year. All right, John, send me an order in that case.
Thank you,
Also,
Nancy.
Yep, thank you.